My name is Kate Brady, and I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America. This webinar today is going to be on naturalization to become a United States citizen. I'm going to walk you through the nuts and bolts of this, and then we're also going to talk about some of the exceptions and some frequently asked questions and how that intersects with the work that CLCMA does in our impact litigation. And then I'm going to give you a little bit of an insight into what we do as an organization. So generally, the qualifications for citizenship are listed in the Immigration and Nationality Act. Sometimes we abbreviate that as INA. And to start with, applicants must be over the age of 18 to apply for naturalization. There's some other ways that minor children who are not born in the US would be citizens, but we'll get into that in our other webinar on derivative citizenship. So I hope you take a look at that as well. The first thing is that you have to be a green card holder or a lawful permanent for the 5 years immediately pre date of this filing. That means that you could have been a resident for 20 years, but we're really going to look at the last 5 years. And that's the statutory period of time that really makes a difference. During that period of time, you have to have had continuous residence. That does not mean that you never stepped foot outside of the United States, but you break your continuous residence when you've been out of the United States for 1 year. And at that 365th day, you fall under a different section of the law. If you are more than 180 days, there may be a presumption that you're abandoning your residence. And there's some ways that you can make evidence that that has not happened. We'll talk about that a little when we talk about the evidence you should submit. You should also live within the jurisdiction of the USCIS office for at least 90 days. So if you're moving, you may need to wait an additional 90 days to file because you need to have that proof when you go to your interview that you're within their jurisdiction. So other than continuous visits, there is a physical presence requirement. So these are a little bit, and the physical presence requirement means that you need to have been in the United States 50% of the time within the preceding statutory time. For here, we're talking about years. That means you need to have been in the US at least 913 the 5 years in your application. And you maintain that 50% of time between now and oath ceremony. So you cannot be at 914 days and then step out for a long period of time, which might slip you back under the 50%. Again, the time period that's most important is the time period immediately preceding your application. You also need to be able to demonstrate that you can read, write, and speak English, and that you have a knowledge and understanding of the US history and civics. There are some exceptions, and we will talk about that. The reading and writing are tests during the interview, and the speaking English is really if you can have that conversation with the officer. And again, there's another test on that civics during your interview. You must be a person of good moral character. This is an area that has a lot of discretion with USCIS, and there's not really a statutory definition. So it's one of those things that's hard to explain, but one of the reasons why you would be found not to have good moral character for sure is if you had any criminal conviction within that statutory period. I always recommend that somebody wait until they have cleared the statutory period past their conviction before they make that application. The most common one that I run into is being married to a United States citizen. And that actually means that you only have to show a 3-year statutory period. And for both of these applications, either the 5-year or the 3-year, you actually get a bonus of 90 days prior to that time where you can make your application. So at 4 years and 9 months or at 2 years and 9 months. Military members also have an expedited naturalization if they're a lawful permanent resident and they've had 1 year of honorable service in the armed forces. Refugees also have a bit of a bonus. They have a look back period. So admitted as a refugee and then having been a lawful permanent resident, that needs to be a total of 5 years. Some exceptions for residing abroad, they're a little bit varied and we're not going to have all of those. And so I'm going to leave that for another time. If you have a situation where you've been residing abroad and want to discuss it, please do give us an inquiry and we can talk about that. So that civics and English language issue sometimes has a waiver under these exceptions. If you've been a lawful permanent for 20 years and you've reached at least the age of 50, or if you've been a resident for 15 years and been 50 and have reached the age of, you may have an error in your native language from English to your native language to take the civics test, and you will not have to demonstrate English language. If you are age 65 and have been a lawful permanent resident for 20 years, there is special consideration for the civics, and most often what I've seen is both the English language and the civics have been waived. So if you have that and you are able to bring an interpreter, they need to be fluent in both the native language and it will be sworn by the officer who's giving the citizenship applicant's interview. And also it does not have to be a paid certified interpreter. We do prefer that it not be maybe a minor child, but if it is somebody who is 16, 17, 18, that could also be okay. The officer will tell her uncomfortable with your interpreter. So in addition to those exceptions, there are also some accommodations and disability exceptions. These are not about having the right amount of years as a lawful permanent resident or how old you are, but this is physical or medical or mental health. And for this, you will have to look at whether or not the person is either an exception or an accommodation. To be an exception, you need to have a doctor or a psychologist give a medical certification on that form 648. But for an accommodation, this could be something along the lines of a person is visually impaired or hearing impaired. And so they are still going to have tests, but they will have it modified. Maybe they will have a sign language interpreter, or someone who is visually impaired might be given to read in English. Or if they have to be able to write, they might be able to have an enhancement to that. This is a case-by-case situation, the exact same medical condition, but the medical examiner may not be able to give you that same exception. So once you've gotten to the point where you're ready to apply, you make that application. It's a very long one, it's very complex, and it's about 21 pages at this point. One of the cool things I think that you can do within your naturalization is you can make a request to change your name. It's part of the application, and then what happens is at the end, if you're approved, you will be sworn in and have your name changed at the exact same time in front of a judge. You will get your certificate in your new name, and you will also have a court order saying that your name has been changed. The application can be filled out online or by mail, and the preference is that it be done online. The fees can be done that way, and also you can upload your supporting documents, which are going to be a copy of both sides of your green card, your passport since becoming a resident, and these are the things that would show that you have maintained your physical presence in the U.S., things about your recent taxes, your continuous residence. Those are important if you think you've been out of the United States too long. And as I said, people are sometimes going to have criminal records. If you have that, that is also a supporting documentation that needs to happen. You need to see the arrest report and the court documents. That is something you need to go and get those from the organizations, from the police and from the court where those reside. Just as in every other application, there's usually a biometrics appointment, so you get your receipt notice, and then soon after that, there will be a biometrics appointment where you're asked to come for a specific day and time. They will take your photo and they will take your fingerprints. That photo is the one that is most likely to end up on your naturalization certificate. I always tell people, like what you look that day, because you're probably not going to get another chance. And then you will be interviewed in person. This website down here is a pretty good guide from USCIS if you have other general questions that might walk you through what to expect. But it is a complex and long application. And that's why it is important, if you think you have a situation that is different, that you do try to get a consultation with an attorney, because all of those questions must be answered, and some of them are clear and some of them may not be so clear. Things like listing all your trips outside of the United States for more than 24 hours during whichever statutory period applies to you. That sometimes trips people up because they are not sure if they need to do things like if they went on a cruise or if they went to Hawaii. Some people don't understand. We don't consider that outside of the US, even though you went on a very long plane ride. So that could trip some people up. You need to be very accurate about your marital history, including if you have issues with a prior marriage annulled or it wasn't very long, those still need to be listed. And you need to be as accurate as possible about divorce information, which should be something you can find in your court documents or whatever legal document terminated your marriage. You should list all your children, your adult children and your stepchildren. That can be very important later if you want to petition for them, because if you did not list them, they might wonder why. And if you had that relationship prior to naturalization, they should have been on that form. This is a big one for our organization, group affiliations. And this is big because there are a lot of organizations that are either charitable or military or that you belong to while you were a student that are under scrutiny from the US government. And this question is about ever in the US and abroad. And so this question trips up a lot of people if USCIS is for a reason to make trouble or deny your application. They will ask this question in a way that makes it so that if you did not fully disclose dates and organizations, they might question whether you have had fraud or misrepresentation, or even more serious, if you're a national security threat. The questions on page 14 about criminal issues are also really interesting to me, and one that a lot of people don't understand. Some of these questions don't sound like ones that would really be asked. The first one that I have here, have you ever committed a crime for which you were not arrested? This is a question that if you answer no, but later have committed a crime, and the time period where that crime started was before you were naturalized, there may be a reason for the government to start civil denaturalization proceedings against you. There's several applications out there that are in the news where crimes were discovered later, they actually pled guilty or were found guilty, and they are actually being pursued for denaturalization. And the second one that I have on here, question 23, have you ever been arrested, cited, or this trips up a lot of people because they think that if they were expunged or deferred adjudication, they don't have to list it. But if you look at the application, it actually lists all of that. Even if you've been told by a judge, by an attorney, by somebody that it doesn't matter, these should all be listed. And another one is that traffic citations are considered citations. We often call them tickets, but they should be listed. We do actually have a case within our CLCMA caseload that is about one that the applicant did not list citations because they did not think that it meant the same thing as being arrested or detained. Everybody will be interviewed at a USCIS field office. An officer, when you come into that interview, will swear you in to tell the truth and will also ask to look at your identity documents. So one of the things that you must bring is your green card and your passport. I've often seen officers start when they administer the test. It doesn't really matter which they go in, English or civics, but that is usually before they go over your application. The English portion is pretty simple. You're going to have to read a sentence, and then you're going to usually be told the answer to that sentence. One that I give people an example of is, when is Independence Day? Will be the question that you have to read, and the Independence Day is on July 4th. That may not be exactly how it is, but that's one that I've heard before. And then if you get both of those passed, in the civics section, when you were given that booklet at your biometrics appointment, there's 100 questions. Every applicant is randomly given 10 of those questions, and you have to get 6 right. It doesn't matter if it's the first 6 or if it takes you all 10. Once you get 10 right, then you move on. If you fail either of these tests, you are given one more chance within this application, usually 45 to 60 days later. If you fail a second time, that is the end of your application. Your fees are taken, that time is wasted, and you will need to start over again. Then the officer will review your application. All of the questions on your application, all of the data, there are over 80 questions that they'll usually go over each and every one of them and confirm your eligibility. You are able to make corrections to your application at that time, and that's regardless of whether you thought the question was one answer and it's different, or the circumstances have changed. Maybe you've moved, maybe you've gotten married, maybe you've had a child. All of those things can change, and you can make those corrections, and you should make those corrections. An attorney can be present in your interview, and for that, they will be answering legal questions. Factual questions will need to be answered by the applicant. So there may be times where eligibility is an issue, and maybe the officer is looking at the wrong category, and that's the attorney would step forward. But if they're asking simply questions about how many times you've been married or whether or not you have children, that is a question only for the applicant. And again, if you meet one of those English language exceptions or need an accommodation for a disability, your translators or your accommodator can be with you. So let's talk about some of those outcomes. The one that we all want to hear, you've been recommended for an approval. Your oath ceremony is scheduled, and often it is not going to be the same day, even though that used to happen more often. It is not now. Your date will be mailed to you, and you should be watching the online system to see that that is in process. The officer at the interview can actually hand you that asks permission, or they can you. It's kind of like a request for evidence in some other contexts. They can actually call you back in for more interviews, and this is trouble. If you went without an attorney the first time and you get called in for another interview the second time, do not go without an attorney. This is very infrequent, and this is trouble. After your interview, there could be a delay, or you could be delayed for your interview for years and years and never be interviewed. Those are reasons to explore federal litigation. After your interview, you might be issued a notice of intent to deny. And that means you may be requested to explain some of those questions that happen in the interview that they think you're ineligible. You get a chance to make a legal argument in writing and potentially put in some more documentation. If they still deny your case, there's an administrative procedure by the N336 that's called a request for a hearing, but it is administrative. It goes back to USCIS, and typically another officer will be looking at your case. You could write a brief that explains things similar to what the notice of intent to deny is, and you will also be sitting in front of an officer making a plea for your case, an oral argument in front of them, usually for just maybe half an hour. It is an administrative formal hearing, but it is administrative. If after even all of that, your case is denied, this is also an area where it would be ripe for federal litigation. We do have several cases that we have either done in the past or currently doing. So we are really hoping that you get that positive outcome, and then you're going to be able to take that oath of allegiance. It may be in a large or a small group. It may be administered by USCIS or a judge if you've decided to change your name, and it is usually not the same day. Your family and friends may attend in normal circumstances, but right now with the COVID-19, we do not expect that even small group ceremonies will happen. They'll probably wait until that is over, and they may even also limit the number of people who can come. You will receive your certificate of naturalization at the ceremony, and that's exciting because it means that you're immediately eligible to take that certificate and apply for your passport, to petition for other relatives, and to register to vote. So as always, it is very important that you keep USCIS apprised of your address, because that's where they're going to mail your notices, and that is also how you're going to know when you get that notice to come for your interview and also for your oath ceremony. You should also always update the U.S. Post Office, because you wouldn't want to have them return mail to USCIS when you are at the right place. I'm going to give you a little bit of a rundown of some frequently asked questions. So here you are, you've passed everything, the application's been approved, and the question may be, can I lose my U.S. citizenship? And the answer is yes, but it is extremely infrequent. We do have another webinar from the Civil Litigation Department about denaturalization and how that civil proceeding goes. But I will just tell you that there are some reasons why they will look back, like we talked about that criminal case that happened prior to your naturalization, but you answered no, that you have never committed a crime for which you have not been arrested. And also in that other webinar, you'll see you are a member of certain organizations within 5 years of your naturalization. You could run the risk of having that civil denaturalization. But in general, if none of those apply to you, citizenship is a permanent status. And now you're eligible to sponsor more people. You can sponsor your spouse and children like you always have been able to, but now your children don't need to remain unmarried. They can be married children. And you can also petition for your own parents and your siblings. There are some pretty cool things that could happen when you're naturalized to your spouse and kids. If they're immigrating, this could mean that they're in a category that is moving a little bit fast, and so their cases will be upgraded. Sometimes you do have to make that request, but that is what they're eligible for. Your spouse and kids could actually be in the immediate relative category. So if they've been waiting a long time, this could mean that their wait is significantly shorter. And usually you will not be able to be eligible for deportation. But as we talked about in the first question, if you lose that citizenship, you will revert back to being a lawful permanent resident, and then you are in jeopardy. Usually no, but sometimes yes. And we talked earlier about having to continuously reside in the US. There used to be a retention requirement for US citizenship, but about 40 years ago that changed. So you can now live outside of the United States as a US citizen, and it does not jeopardize your US citizenship. I'd like to give you a little bit of an insight into how some of these cases intersect. I've maybe given you some hints at that, but let's talk about these. One of the biggest ways is in delays and denials for national security reasons, the Controlled Application Review and Resolution Program. This is something that we see quite often because cases are languishing years and years. Even though this administration takes a long time, if you are going well beyond the processing time and you've had other issues in the past where you know the government has asked questions about your applications, at citizenship, it's no different, and this could be a reason for us to be involved, and we would look at it to see if you could be one of our cases. Also, there are cases that we have done that have challenged general eligibility, including whether the initial grant of lawful permanent residence was correct, such as were you in a category where you should have remained unmarried and they think you were married, or you were in a category where you were a spouse and they think that marriage was a sham or fraudulent. Again, fraud or misrepresentation. That could be as little as you thought a question was one answer and they say it was another, either on your residence or on your naturalization, and they are actually claiming that you made an intentional misrepresentation. We do have at least one litigation case that has that component. We also see a lot of times where either individuals were approached to be FBI confidential informants, or a confidential informant might have been within their circle of influence. And then if they did not agree to cooperate, things started going very wrong in their immigration cases. And we are looking closely at those through our criminal section, especially for FBI requests for interviews. So if that has happened to you and you are having troubles, that may be a reason to give us an inquiry. This stands for the terrorism-related inadmissibility grounds. Again, it's a national security issue. There are lots of reasons for maybe affiliations with military when you were outside of the United States, or charitable organizations that are now disfavored, other organizations within the United States that the government is now looking closely at. So I would say if you think that there are some common issues that you have that the government has been questioning those organizations and your case has been delayed several years, this is a reason why you should talk to us. I talked a little bit about DNATs. We do have several past and current cases that have to do with that. And we do also have a couple where passports have been seized, which does not revoke your citizenship, but it does revoke that document, which makes it very difficult to have proof of your citizenship and also to be able to travel freely. So at CLCMA, we do impact litigation. General immigration is a lot of those cases you think about where it's applying for lawful permanent residence, or maybe deportation defense, or citizenship in a general context. So it's very broad and complex, and we need to know that information for when we talk about our impact litigation, because we need to know when it's gone wrong. When you come to us and you have a situation, we can look at it and say, no, you're being treated just like everybody else because everybody's waiting this amount of time, or wow, your case has been delayed a really long time and we want to look at. And most attorneys will not turn to litigation. They will try to stick to things like their petition-based applications. And that means we are looking at those cases that take a very long time, and we want to know that our time is being spent wisely. So every year we might get hundreds of intakes, and we're going to take those in, look at your situation, decide what our recommendation is, and send that recommendation to our board of directors, who will facts and circumstances and our available resources. And if they say yes, you're going to become one of those impact litigation cases. And what we mean when we talk about that is cases where we're going to fight for discrimination, against discrimination and injustice by the US government in the areas of constitutional violations and civil rights violations based on race, religion, or country of nationality. And those are usually things that are very factually complex, and they may have that national security component. So even though we accept fewer cases out of the hundreds that request our services, we know that we are going to be in it for the long haul and vigorously represent these cases, because our goal is to make a community impact. Every good win means that hundreds of people will be able to benefit from that good win. So if you're just wondering, do I even need an attorney? Sometimes you think it's just filling out forms. As we've talked about, they're very complex. This one is 21 pages. Maybe your relatives have done it without an attorney, or you think it costs too much, or you think your case is simple. I will tell you it is until it's not. We have had, as I say, cases where that change of address was not done, or a box was checked and the US citizenship said that it was a misrepresentation, and now they are in litigation. So if we can't take it because you are a general immigration case or you're outside of the scope of what we do, I will give you resources. This is a general list of the resources. Many times I will give you an email that is a little more specific with these organizations in your area, and then you can do your own due diligence. But what I really would like you to know is that it's been a pleasure here today to present this webinar to you. I hope you've been more informed after it and that we've helped you. If you would like to know more about our organization, please do see our website at www.clcma.org. And my name is Kate Brady. I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America, and I appreciate your time. Thank you.